Do you know the difference between a real conspiracy and a mere conspiracy theory? See if you can tell the difference with my true story. Attorney General Javier Becerra abused the power of the California Department of Justice. The DOJ maintains that abuse, which continues to harm an elderly retired healthcare worker, immigrant, and homeowner, my mother, into a state of constant fear. She now conceals her identity in this show in order to file criminal charges against AG Becerra for having violated her constitutional rights under the color of law. Yet President Biden appointed AG Becerra, without experience, to Secretary of Health and Human Services, the federal agency responsible for handling the pandemic and the immigration crisis. AG Becerra was not the first officer of the government to abuse my mother. This elder abuse started 14 years ago, in 2007, with San Diego District Attorney Paul Greenwood. In 2012, Attorney General Kamala Harris got involved. In 2018, my mother was nearly killed as a result of 11 years of abuse. AG Becerra's crime is so disgusting, egregious, enduring, and well-documented that attempted murder is not out of the question. The motive is to keep this enduring elder abuse quiet. On the other hand, consider that on March 8, 2021, the Biden administration openly claimed that Russia had mounted a disinformation campaign regarding the safety and efficacy of the American coronavirus vaccines. In this first show, I ask who actually is to blame for any skepticism in taking the vaccine and for the out-of-control immigration crisis. I prove that America is not a nation of laws, it's a nation of tribes. America is not composed of three co-equal branches of government. Consider this question as evidence of my claim. If Trump's lawsuits had managed to overturn Biden's election, then by overturning the will of the American people, wouldn't the judiciary be the most powerful branch? The election wasn't overturned because the judiciary is not blind to the will of 81 million voters. George Floyd changed the law within 1 year of his being murdered because the legislature is not blind to the will of 26 million protesters. But the judiciary, in fact all of government, turns a blind eye to its own endless, inhumane torture of an elderly immigrant retired healthcare worker. During a pandemic, when healthcare workers are America's frontline soldiers, that adds insult to injury. Ultimately, I proved that justice in America was never blind. That was just an old wives' tale. Welcome to Aerofusion.com, the official home of the Build Back Better show. I'm your host, Hans Cruteau. My show is your opportunity to tell the government what it will take to build back better. My aim is to make politics feel good. Each month, I'll explore and expose a leading pre-pandemic cause of social, commercial, environmental, and governmental dysfunction. I'll focus on vulnerabilities that ultimately led to the demise of America's democracy. Together, we'll explore science, technology, and humanities in search of answers. We'll debunk conspiracy theories and expose America's anti-democratic policies. Learn about my legal struggles against discrimination, bias, and hatred in the first show. Learn about my experience and qualifications to be your host on the About Me page of Aerofusion.com. Each show is in plain, non-legalese English. All exceptions are made clear. Main shows are monthly. Follow-up shows may be up to weekly. Don't miss out. Subscribe now. I now expose the endless elder abuse of my mother, Miss Bernier. In fact, I too have endured 14 years of related abuse so far. If you haven't seen my 5-minute cartoon, then please check it out. It too is on my YouTube channel. That cartoon and the About Me section of Aerofusion.com now christen off the Build Back Better show. That's because you, my audience, need to know what makes me qualified to be your host. The 14 years of oppression that we've endured at the whim of the American government, as told in a comical light, in an entertaining, feel-good way, demonstrates my qualifications to be your host. Miss Bernier and I are Canadians who immigrated to the United States in 1982. Immigrants are often openly accused of taking American jobs, even the jobs that Americans won't do for themselves. Few immigrants ever get to be well connected to powerful American tribes. After 25 years of being a registered nurse for the San Diego Sheriff, Miss Bernier hired and paid a U.S. citizen over $200,000 to remodel her home in order to retire in peace. Instead of a remodel, he took her money and abandoned her home without a roof, a second story, exterior walls, doors, and windows. 14 years later, her home is still not repaired. In addition, she's been denied an investigation by all law enforcement, both state and federal, all while being dragged into court for the past 14 years by the contractor who destroyed her home. That contractor is her own son, who profited with judgments of almost $2 million against his mother and her lawyers. Meanwhile, we've been living like fugitives with targets on our backs. The judge who issued those targets then withdrew the baseless order over 14 years ago, but the damage had already been done. The criminal who tricked the judge was never investigated. In fact, law enforcement permitted the crime to continue. Officers of the court aided, abetted, and perpetrated this crime. Because powerful insurance, lawyers, and government agents, like the district attorney, Department of Insurance, and Department of Justice are involved, the judiciary keeps this abuse quiet in order to save face. Every time Miss Bernier tried to redress her grievances, the government retaliated because she had dared to exercise her First Amendment right. In 2017, the court subpoenaed her. When she complied with the subpoena, a federal target was placed on her back for having complied with the subpoena. Nothing could be more chilling. This conspiracy has gone beyond constitutional considerations. It's against her human rights. It has no end. It's designed to harass and to deny meaningful access to the courts forever. Local, state, and federal government, including the judiciary, now have their heels dug into this dispute. They all share a motive to keep this abuse quiet. If the truth comes out after 14 years of growing abuse, public confidence in the judiciary will wane. This abuse is intentional. It's not a mistake or an accident. The private interests of tribal businesses, such as insurance, is well connected to the judiciary, one of three supposedly co-equal branches of government. That's why the abuse continues unabated. A.G. Becerra falsely claims that he was only representing another California elected official, Insurance Commissioner Ricardo Lara. In fact, Governor Newsom refused our pleas for help because Commissioner Lara was elected by the people over which Governor Newsom had no control. Commissioner Lara was elected by the people to enforce California insurance laws. It's not in the financial interests of Commissioner Lara or that of Travelers Property Casualty Insurance Company for the people of the state of California to learn about what Travelers has done and continues to do. Travelers pays fees to the CDI and taxes to the state of California, but Travelers makes even more in profit out of the pockets of its people who will undoubtedly refuse to get insurance with Travelers after they see proof of its abusive behavior on this show. To the extent that the U.S. DOJ refutes my proof, then I invite the DOJ to respond meaningfully to all issues that my mother and I have raised for the past 14 years in all of our pleadings. In 2012, after 5 years of abuse and denial of investigation by all law enforcement, and in response to being dragged into court again, the matter went beyond constitutional considerations. Miss Bernier's human rights had been violated. Miss Bernier and I claimed judicial terror in California State Court. We won that battle, but that victory caused the retaliation to get worse. In this first show, I demonstrate a pernicious pattern of abuse by all officers of all courts. A real and verifiable conspiracy to unjustifiably brand my mother and me as vexatious not only went unabated, but it was assisted by the government. And when you have a target on your back that's contrived by the government, no officer of any court is capable of laying an even hand on the disputed matter. After 14 years of violating our First Amendment rights, in order to defend my mother, I now have no choice but to produce this show. Without this show, our criminal complaint against Javier Becerra would be ignored. I claim that this show is the voice of the voiceless. As an olive branch to the Biden administration, I now call it the Build Back Better show. When you're the victim of an endless crime because the courts put an unjustified target on your back in the name of the criminal who's victimizing you, that judicial terror becomes a matter of international human rights, not just American constitutional rights. When you've been mugged, you can complain to the local police. When the police mug you, you can complain to Internal Affairs or to the district attorney. When the district attorney violates your constitutional rights, you can complain to the Department of Justice. When your insurance company violates its fiduciary duties, you can complain to the Department of Insurance. When your attorneys violate their fiduciary duties, you can complain to the state bar, who purportedly answers to the state Supreme Court. When your private attorneys, the DOJ and CDI, violate your constitutional rights, you can complain to the federal courts. But when your private attorneys, the DOJ and CDI, act in concert with federal judicial corruption to keep it all quiet, it becomes a matter of international human rights. The Inter-American Commission on Human Rights is located in Washington, D.C. That creates an appearance of bias and influence over the enforcement of human rights in the U.S. As explained on Aerofusion.com, my show is presented in plain, non-legalese English, and all exceptions are made clear. This first show is one such Kafkaesque exception. In order to prove my point, I have no choice but to get into some legalese explanations because judicial corruption is involved. But if you stay tuned until the end, you'll see me address the Biden administration, and I'll be orally summarizing my criminal complaint against Javier Becerra with the U.S. Department of Justice. In 2007, Ms. Bernier paid her son Jesse about $200,000 to remodel her home. Her home used to look like this. Jesse destroyed her home. He then abandoned it. It's illegal to take the roof off of a home without plans or a written contract, so he forged her signatures on false contracts. At the same time, without notifying us, a judge ordered a false target be placed on our backs. When valid, these types of orders can deny a litigant access to the court, but access to the courts to address a genuine grievance is never valid or justified. The judge did not notify us that he had ordered the target. We were not provided a hearing or any opportunity to be heard. The judge withdrew the target as a baseless order that had been signed in error, but the damage had already been done. Jesse then conspired with District Attorney Paul Greenwood to continue to peddle and promote this baseless expunged target on our backs. That's when it became a big lie. Attorneys General Javier Becerra and Kamala Harris, Insurance Commissioners Dave Jones and Ricardo Lara, County Supervisor Diane Jacob, and District Attorneys Bonnie Dumanis and Paul Greenwood aided, abetted, perpetrated, or promoted the big lie in concert with travelers in order to deny Ms. Bernier an attorney and complain to the courts that she has no attorney, so the courts would dismiss her claims without reading her pleadings and without ever providing a meaningful decision. 14 years later, my mother and I are still denied our due process rights. For 3 reasons, I claim that these 7 government officers acted in concert with Jesse and Travelers to perpetrate and promote the big lie. First, Travelers owed her an attorney pursuant to her insurance policy, but it also had a motive to deny her that claim because it had already paid Jesse $325,000 out of her homeowner's insurance. Second, that payoff was explicitly unlawful under California Insurance Code Section 533. And third, Commissioners Jones and Lara refused to enforce the insurance laws against travelers. Each year since 2012, in violation of Insurance Code Section 12921.1, Commissioners Jones and Lara misreport travelers' despicable conduct to the California public in order to keep this elder abuse quiet. Jesse had concealed his liability insurance with United Contractors Insurance Company. That extrinsic fraud and the big lie is the reason why Miss Bernier's home remains dilapidated 14 years after Jesse destroyed it, despite his liability insurance with UCIC and her homeowner's insurance with Travelers. UCIC never investigated. It never paid her a dime. Instead, it paid Jessie $75,000, withdrew Miss Bernier's coverage for the damages that Jessie had already done to her home, and paid Jessie's lawyers to keep harassing us until that financial pressure caused its liquidation in 2013. In 2021, its liquidation attorneys admitted to us that it did not have a legal right to withdraw Miss Bernier's coverage after Jessie's liability coverage had already inured to her benefit. Its liquidation money has yet to be dispersed to Miss Bernier. In 2019, the current district attorney acknowledged the ongoing elder abuse, but he refused to investigate because the former district attorney had also refused to investigate over a decade ago. The big lie was the only basis for both refusals. Despite being the victims and denied an investigation of this ongoing abuse, Miss Bernier and I are the ones who are continuously dragged into court and harassed over the unresolved destruction of her home. In 2017, Jessie harassed us with a subpoena to make a profit of $1.4 million against our prior attorney, Glenn Rosen. Mr. Rosen claims the entire saga has destroyed his family, his marriage, and his emotional well-being. Attorney Rosen appealed that $1.4 million judgment to the California 4th District Court of Appeal. A.G. Becerra intervened in our concurrent Ninth Circuit appeal of the dismissal of our civil rights complaint, seeking to enjoin Attorney Rosen's appeal in order to respond to Jessie's harassing subpoenas. A.G. Becerra intentionally refused to act before the oral hearing of Attorney Rosen's appeal so that the resulting 4th District decision could be used to promote the big lie. The enduring dilapidated condition of Miss Bernier's home caused black mold that nearly killed her in 2018. After personally witnessing the condition of her home, even local police can't believe that the courts are so inhumane and vicious. They don't understand why the courts would accuse us of being delusional and having a vendetta against Jessie and travelers. Yet the current district attorney still won't investigate. Even worse, in 2020, A.G. Becerra promoted the big lie with the Ninth Circuit. When Jessie harassed us again with subpoenas in 2017, Jessie triggered the provisions of Travelers' illegal payoff contract. That contract had named us as its third-party beneficiaries. Yet Travelers denied our claim for an attorney to resolve the confusion and the threat of contempt of court from Jessie's subpoenas. Kamala Harris got involved in 2012, the same year that Travelers paid Jessie $325,000 to have him dismiss his malicious prosecution lawsuit against us. You heard me right. Jessie took about $200,000 from his own mother, destroyed her home, left it in this condition, and then he sued us, alleging that we had sued him with malice. The big lie was his only reason to sue us for malicious prosecution. The state contractor's license board had already cited Jessie for having destroyed and abandoned her home. The judge in the first lawsuit prevented Miss Bernier from ever being compensated. As a result, that judge set her up to be sued for malicious prosecution over and over again, with the big lie being the only grounds each time. Litigants have the right to present issues that are arguably correct, even if it's extremely unlikely that they will win. It was Jessie's claims for malicious prosecution against us that were frivolous, malicious, and extremely unlikely to win. In fact, Jessie did not win his malicious prosecution case. Travelers was being concurrently sued by Miss Bernier. So Travelers illegally settled Jessie's frivolous case to keep us from clearing our good names by debunking Jessie's groundless accusations. Travelers' illegal settlement then formed the basis of Jessie's subsequent malicious prosecution lawsuit against our prior attorney to make him a profit of $1.4 million off of his continued harassment of Miss Bernier and me. Before it paid Jessie illegally, Travelers had already told us that this type of abuse is exactly what the law was intended to prevent. Beyond the fact that Travelers had a motive, the fact that Jessie's lawsuit was for malicious prosecution is what made it illegal for Travelers to settle it. The fact that Travelers told us that any settlement would be illegal proves that it was intentional, not just a civil wrong or mistake. That's why Commissioner Lara's law enforcement duties were ministerial, perfunctory, and unavoidable. The law is clear that insurance can never indemnify malice. Malicious prosecution is a subjective, quasi-criminal, state-of-mind accusation. It's the most contentious and difficult thing to prove. If the accusation is correct, then indemnification encourages more malicious prosecution. If the accusation is false, then indemnification encourages more frivolous lawsuits purportedly for malicious prosecution. The latter is precisely what happened in this endless family financial elder abuse saga. The proof is that Jesse filed another frivolous malicious prosecution lawsuit after Travelers paid him off. In fact, it was Travelers that told Miss Bernier Insurance Code Section 533 strictly prohibited settlement according to Downey Ventures versus LMI Insurance Company. As soon as the financial pressure caused Miss Bernier to file for bankruptcy in 2012, Travelers negotiated to pay Jesse $325,000 without our knowledge or that of our attorneys and in violation of her bankruptcy stay. We waived the policy and fired the lawyers that Travelers had appointed us. Travelers ignored us. It's illegal for an attorney to represent a client against his or her will, but those attorneys ignored us and did whatever Travelers told them to do because Travelers was holding the purse. Miss Bernier's bankruptcy stay was lifted. She appealed, but Travelers paid Jesse before that appeal could proceed. Travelers rendered Miss Bernier's appeal moot. Travelers would not have acted in such bad faith without the false targets on our backs. Travelers had a bad faith motive to have Jesse dismiss his frivolous malicious prosecution lawsuit. By paying Jesse, Travelers avoided a public trial. A public trial would have exposed how Travelers had mishandled Miss Bernier's claim that Jesse had left her home uncovered without a roof in 2007. That would have condemned Travelers in Miss Bernier's own separate pending related lawsuit against Travelers. To clarify all of this, I need to explain the whole story, starting in 2007. In 2007, after taking hundreds of thousands of dollars from Miss Bernier, Jessie went on vacation and left her home uncovered without a roof. Travelers saw her roofless home after it rained inside her house. Jesse told Travelers about his forged contracts, about his plan to accuse Miss Bernier with a big lie, and about his liability insurance with United Contractors Insurance Company. But under oath, Jesse denied having liability insurance to Miss Bernier. Travelers knew of UCIC, but in concert with Jesse, Travelers also told her that he had no insurance. While everybody was decorating for the 2007 holidays, her home was a circus tent. 9 months after its demolition began. This is how we spent Christmas of 2007. My mother and I have not been able to celebrate Christmas since 2007. In fact, to add further insult to injury, Travelers paid Jesse the $325,000 on Christmas Eve 2012 and then told the courts that it did not understand how this could add insult to injury. We learned of the big lie and the forgeries in July of 2008 after Miss Bernier sued Jesse. Jesse had lodged those documents in court to declare Miss Bernier vexatious and to have her post a $100,000 bond in his favor. Miss Bernier notified Sheriff Hale, who confiscated her copies of Jesse's forgeries. Sheriff Farneau investigated. D.A. Paul Greenwood ignored the evidence that Sheriff Hale had confiscated. He waited for the judge to decide the civil dispute. By failing to act on his knowledge, D.A. Greenwood intentionally permitted Jesse's fraud to taint the outcome of the civil trial. The judge then held Jesse's forgeries in the judge's chambers for 6 months in order to give the DA a chance to confiscate them. Instead of stopping a crime in progress, D.A. Greenwood accused Miss Bernier and me of being vexatious Canucks. He relied on the tainted trial outcome to not confiscate or inspect the forgeries in the judge's chambers. D.A. Greenwood spoke to Jesse, but not to me. He claimed that my testimony would be necessary, but that I would not be credible. He did not specify what I purportedly wouldn't be credible about. In an email to Miss Bernier's attorney, D.A. Greenwood admitted that the big lie had been his only grounds. Even worse, he aided and abetted Jesse by writing him a letter without notifying Miss Bernier or me. That letter cleared Jesse from Miss Bernier's charge of forgery without first inspecting the evidence that Detective Hale had confiscated. That same letter helped Jesse sue UCIC. In the letter, he claimed that Miss Bernier and I were the ones who were actually under investigation. The current DA refuses to tell us what DA Greenwood was investigating us for over a decade ago. The current DA has his own attorney who claims the attorney-client privilege over DA Greenwood's file on us. That attorney knows that if we file a Freedom of Information request, the court will ignore it and the big lie will be the only justification. DA Greenwood refused to investigate the big lie, not just the forgeries. The presiding judge admitted that he had signed the false target order in error, but the DA had a responsibility to investigate its origins. 14 years later, the person who brought the false order to the presiding judge, most likely Jesse or an officer of the court, remains at large. That person's name was intentionally left blank on the false order. We contacted the only name on the order, Millard Universal Enterprises. MUE denies having anything to do with it. No. DA Greenwood refused to investigate why the order was presented to the presiding judge instead of the judge in the MUE matter. The MUE matter had been closed 5 years before the date on the order. In his order withdrawing his own false order, the presiding judge admitted that he had failed to review the file in the MUE matter before he signed it. Because the presiding judge was involved, the DA did not investigate this extrinsic fraud. DA Greenwood permitted Jesse to continue his fraud and waited for the civil judge to figure out Jesse's criminal fraud. The civil judge relied on the attorneys. Ms. Bernier's attorneys relied on the DA to investigate the crime. It cost nothing, and there was no risk for Jesse's attorneys to push the big lie at trial, a year after the presiding judge had already withdrawn it, because the DA had already agreed with Jesse to not investigate the forgeries or the big lie. After having lost hundreds of thousands of dollars and living in a destroyed home, travelers paid for nothing. Ms. Bernier paid for everything. She paid the lawyers, the experts, and all court fees. Jesse had no experts and paid for nothing. Ms. Bernier's attorneys did not prepare. Both sides were unprofessional. With the big lie, but without facts, Jesse accused Ms. Bernier of fraud, drugs, moral turpitude, and vexatiousness. The judge had an obligation to stop this abuse. Instead, midway into trial, he said, quote, "At least one party will be disappointed in the outcome," unquote. The judge had already decided not to listen anymore. The judge then said, quote, "It's been proven that Ms. Bernier is a vexatious litigant, at least as of October 16, 2007, unquote, the date on the false big lie target order. Not surprisingly, the judge found that all testimonies had been inconsistent and improbable, but he also found that each of their testimonies had been false without specifying anything in particular. That trial transcript cost Ms. Bernier another $5,000. Clearly, Ms. Bernier never got any benefit from her insurance with Travelers. In fact, without Travelers, our misery would have stopped there because Jesse would not have had a means to profit off of Ms. Bernier's insurance coverage by promoting the big lie. So he sued us for malicious prosecution and tendered our defenses to Travelers to get paid from her homeowner's insurance. Naturally, we were suspicious. Travelers and its attorneys told us about Downey Ventures versus LMI and advised us that Insurance Code Section 533 made it illegal for Travelers to settle Jesse's frivolous case. As soon as Travelers negotiated to pay Jesse $325,000 without our knowledge or that of our attorneys discontinued their advice on coverage issues. We claimed a conflict with Travelers. In order to avoid the illegal payoff contract, we unconditionally waived the policy benefits that Ms. Bernier had already paid for. We fired our attorneys, but they refused to comply. Travelers told our attorneys to refuse to substitute out of our defenses. Our attorneys did whatever Travelers told them to do because Travelers was holding the purse. That's when Ms. Bernier filed a consumer complaint with the California Department of Insurance. So Travelers made those attorneys stay in our defenses just long enough to shove its illegal payoff contract with Jesse down our throats. We never signed that payoff contract. It states that Travelers and Jesse realize and understand the risk of future claims. But Travelers wanted to avoid years of costly litigation and to eliminate any monetary damages exposure to us, whether or not covered by the policy. It entitles us to a summary procedure in court if it's breached, but it also places the burden to enforce that judicial procedure on us. Before Travelers agreed to pay Jesse, Travelers knew that our attempts to challenge the illegal payoff contract would be dismissed under the big lie. If not, then Travelers would file a vexatious litigant motion against its own insureds based on the big lie to make it so. Indeed, Travelers repetitively filed specious vexatious litigant motions against us in state and federal courts. The Department of Insurance was aware and ignored all of our pleas for help, just like the DA had done. The payoff contract is illegal for several reasons. First, like I said earlier, Insurance Code Section 533 prohibits indemnification of any malicious prosecution claim. Second, its negotiation during a bankruptcy stay was illegal under Title 11 U.S.C. Section 362, the automatic bankruptcy stay. Even the bankruptcy judge erred by lifting Ms. Bernier's bankruptcy stay to permit Travelers to pay Jesse because only her defense was broadly covered. There was no reason to lift her stay because Jesse's claims were not even narrowly covered. The law precluded Ms. Bernier's policy from being abused in that way. Ms. Bernier appealed, but Travelers rendered that appeal moot by paying Jesse before that appeal could proceed. Travelers would not have engaged in this type of bad faith without the big lie. Regardless of the legal details, any reasonable person should understand why it was immoral for Travelers to pay Jesse $325,000. Jesse stole hundreds of thousands of dollars from his mother. He destroyed and abandoned her home in this condition. He concealed his liability insurance from her, and he harassed her into bankruptcy with a frivolous lawsuit. Travelers' response to the CDI was not reasonable. Travelers promoted the big lie to the CDI. Travelers admitted that it had indemnified a malicious prosecution claim. That's the only fact that the CDI needed to know in order to take its final action against Travelers pursuant to California Insurance Code Section 12921.4. It's been 9 years since Ms. Bernier filed her complaint with the CDI. The CDI refuses to take its final action due to all prior litigation and because no court has ever meaningfully decided anything. That's exactly why the CDI must take its final action. Commissioner Lara's refusal to act is a violation of Insurance Code Section 12921.3. According to Insurance Code Section 790.03, Subdivision H13, Travelers owed us a reasonable explanation for refusing our waiver of policy benefits and for interfering with our rights to clear our good names. In its response to the CDI, Travelers claimed the insurance policy gave it the right to settle any claim or suit that it decides is appropriate. Jesse's attorney told Travelers to rely on the case of Hurwitz v. St. Paul Fire and Marine Insurance Company. That explanation was not reasonable. Travelers had already told us the opposite in writing. The Hurwitz case applies to covered third-party claims. Travelers had already properly relied on Downey Ventures versus LMI Insurance Company explicitly because Jesse's third-party claim was not covered. Travelers played fast and loose with its insureds, the CDI, the courts, the facts, and the law. Travelers and Jesse would not have done this without the big lie. The term of the insurance policy, which states that Travelers may settle any claim it deems appropriate, is void in California under Insurance Code Section 533. Travelers sells this same policy nationwide. When it lied to the CDI, Travelers knew that this policy term may have been valid in the other 49 states, but not in California. That was in plain English. In legalese, the two reasons are that indemnification in defiance of the provisions of Section 533 on the grounds that the term of the policy promised the prescribed coverage would amount to the enforcement of an illegal contract. An illegal contract is void. It cannot be ratified by any subsequent act, and no person can be estopped to deny its validity. That's the same Downey case at page 511. So why does the policy term that Travelers may settle any claim it deems appropriate not apply in California? Because Insurance Code Section 533 is an implied exclusionary clause, which, by statute, is to be read into all insurance policies. That case is JCPenney Casualty Insurance Company versus MK at page 1019. Insurance Code Section 533 is subject to the rules of statutory construction, not to the rules governing contract interpretation. That case is California Casualty Management Company versus Martocchio at page 1531. An insurance policy is a fiduciary contract. The policy term that Travelers may settle any claim it deems appropriate applies to contract interpretation, not to the rules governing statutory construction. So regardless of the policy language, the parties to an insurance policy cannot contract to indemnify a claim for malicious prosecution in California. The public policy of California prohibited Travelers and us from waiving the provisions of Section 533. That's the Downey case again at page 492. In fact, it was Travelers that told Ms. Bernier that Insurance Code Section 533 strictly prohibited settlement. Remember United Contractors Insurance Company? The liability insurance that Jesse testified under oath that he did not have? Well, Jesse sued that insurance too. He relied on D.A. Greenwood's exculpatory letter and the outcome of the first lawsuit to argue that UCIC should have paid for his attorney against Ms. Bernier in that first lawsuit. UCIC settled with Jesse by waiving Ms. Bernier's right to claim latent construction defects and without first investigating her home or contacting her. That waiver was made after Jesse had already destroyed her home. The provisions of Jesse's liability insurance had already inured to her benefit. When Ms. Bernier did file a claim, UCIC denied it and filed for liquidation within a month. UCIC would not have acted this way without the big lie. Ms. Bernier did not choose to be self-represented without first retaining lawyers. Like I said earlier, those attorneys took her money and breached their fiduciary duties by joining the opposing tribes to harass us. The big lie was again the only grounds for this misconduct. Ms. Bernier's own attorney, Alicia Dern, researched Ms. Bernier's lawsuits and contacted her prior attorney, Mr. Friedman, Travelers, Jesse, and others to get their cooperation in designating Ms. Bernier, Attorney Dern's own client, as vexatious, the same way that Travelers had designated its own insured as vexatious. In an email, Attorney Dern explicitly admitted that a conspiracy existed to have Ms. Bernier designated vexatious in order to make her lose her lawsuits and then have her dilapidated property attached upon her death. Attorney Friedman, who represented Ms. Bernier in the first lawsuit, quote, told the insurance company, as all attorneys are doing, that Ms. Bernier is vexatious and that she does not deserve 1 penny for any of her claims, unquote. Attorney Friedman concocted a story about us, and the big lie was again the only basis for that attorney misconduct. Ms. Bernier, representing herself, took Attorney Friedman's deposition. Attorney Friedman admitted his own perjury. Despite explicit death threats and perjury documented by a verifiable deposition transcript, the big lie is the only reason why the State Bar never investigated or disciplined attorneys Dern or Friedman. Not only did this financial oppression drive Ms. Bernier into bankruptcy, but Jesse and his malicious tribe harassed her again during her bankruptcy. That harassment was another breach of Travelers' illegal payoff contract. Jesse also harassed me. He concocted a false story accusing me of vandalizing his property with oil. He connected that false story to the big lie and to Ms. Bernier's bankruptcy. That was more insurance fraud to get his own homeowner's insurance to pay him $8,000 in cleaning solutions rather than to investigate. Jesse's lawyer requested a restraining order that I stay away, not just from Jesse, but from that same lawyer's office too. Jesse's false restraining request was another breach of the illegal payoff contract. Travelers did not appoint me an attorney to defend it. I had to represent myself like Ms. Bernier had done. With no direct evidence but for Jesse's lies, the family court restrained me for 3 years based on the big lie and, quote, out of caution, unquote. Whether wittingly or unwittingly, the family court aided and abetted Jesse to conflate the big lie so that Jesse could make $1.4 million against attorney Glenn Rosen by continuing to harass us. Ms. Bernier and I retained attorney Glenn Rosen in 2013 to sue Jesse for extrinsic fraud and Travelers over its illegal payoff contract. Travelers relied on the Hurwitz case and its false policy interpretation to declare us vexatious and to dismiss our lawsuit unless we post a bond of $100,000 in its favor, just like Jesse had attempted to do in the first lawsuit. It was Travelers that owed us an attorney, not the other way around. The same pattern of judicial abuse persisted. The judge ignored the Downey case. He did not meaningfully respond to any fact or law that we argued. He repeated every argument that Travelers made at face value. So in addition to Insurance Code Section 790.03H13, which is failing to provide a reasonable explanation, Travelers compelled us to institute litigation, which is a violation of Section 790.03H6, and its illegal payoff contract placed the burden to enforce it on us. So we filed an appeal of that dismissal. That appeal was ignored and dismissed because of the big lie. We petitioned to the state Supreme Court and to the U.S. Supreme Court, but we were never granted a hearing. Meanwhile, Jesse dragged us back into court. In hopes of finally getting the court to listen, we had to scream at the court on paper. We claimed ongoing, orchestrated judicial terror and demanded that either Governor Newsom or the DOJ intervene to stop the abuse. We demanded that the attorney the Travelers had appointed us appear at Jesse's motion as a witness. The court denied Jesse's motion that time, but it made no guarantee that the harassment would stop. That's when I uploaded my cartoon to YouTube in 2015. The end of that cartoon says, "To be continued." Although we did not know how he would do it, we expected that Jesse would harass us again with the big lie. Once again claiming malicious prosecution, Jesse retaliated by suing attorney Glenn Rosen in 2015. On February 16, 2017, Ms. Bernier and I were served with Jesse's subpoenas directing both of us to submit to an interrogation in the same attorney's office who had requested that I be restrained from that same office. Travelers refused to get us an attorney. I tried to intervene in Jesse's lawsuit to get Travelers to pay us an attorney to have the deposition taken so that the truth could finally come out. The big lie prevented me from intervening in Jesse's lawsuit. Clearly, all state law enforcement and judicial institutions had become spiteful and polarized by the big lie. We had been judicially terrorized for 10 years, and for 10 years we had been denied our First Amendment right to defend ourselves against that same judicial terror. All of this abuse easily rose to the level of breaching our federally protected civil rights. So Ms. Bernier and I sued Travelers in the federal Southern District. Travelers made another vexatious litigant motion. This time, Travelers relied on the state judge's dismissal that had been based on our failure to afford the $100,000 bond. Once again, Travelers abused the big lie to convince a federal judge to ignore federal law. A vexatious litigant order in federal court must be narrowly tailored to closely fit the specific vice encountered. That case is Ringgold Lockhart v. County of L.A. Travelers and the federal judge relied on the first state judge who found that both Ms. Bernier and Jesse's testimonies had been false. But the problem with that judgment is that it's not a specific finding that Ms. Bernier's behavior was either frivolous or harassing. The first state judge had not said what was false. It's incumbent on the federal court to make substantive findings as to the frivolous or harassing nature of the litigant's actions. That case is DeLong v. Hennessy. Travelers did not give us notice of any frivolous or harassing behavior. The federal judge did not make substantive findings, but he granted Travelers' motion. The judge did not address the illegal nature of the payoff contract, but he issued an order prohibiting us from suing Travelers over the policy in the Southern District, exactly the way Travelers had requested. Our lawsuit asked that Travelers pay us an attorney in order to respond to Jesse's harassing subpoenas. The validity of its payoff contract was the subject matter. Our lawsuit wasn't about the policy. The judge dismissed our civil rights complaint. That dismissal did not address Jesse's pending subpoenas. We appealed to the Ninth Circuit. Our appellate briefs contained the maximum amount of words permitted by law. We also lodged 10 volumes of evidence totaling 2,632 pages. After only 5 days of review, the Ninth Circuit denied our appeal. It recited the elements of Molsky v. Evergreen Dynasty Corporation without considering how the Molsky case could apply to the specific facts of our case. The Ninth Circuit said that the district judge had given us notice and an opportunity to be heard. It said that the district judge had made findings regarding our frivolous litigation history. Curiously, the Ninth Circuit only said that the district judge made findings, not substantive findings. It did not specify what had been found to have been frivolous. Further, the record on appeal disproved that the district judge had given us notice. We petitioned en banc. The en banc was denied without further explanation. We now accuse Ninth Circuit Justices Ferris, Bybee, and N.R. Smith of the same pattern of being spiteful and dishonest as the officers of the local and state governments. It's clear that they did not read our appellate briefs. When they received 9 boxes of evidence and they noticed the big lie, they merely discarded our appeal. The proof is that there is no meaningful response. The record proves that the response that they did make is false. Those paper copies cost Miss Bernier $1,000 to print and mail to the Ninth Circuit. After the appeal, we tried to retrieve the original sheriff's evidence in a sealed plastic envelope that Detective Hale had confiscated. The Southern District informed me that it was now missing and was no longer in the court's files. Even Mr. Rosen explicitly noticed that the state judges are acting out of spite against anyone connected in any way to Miss Bernier and me. Public confidence in the judiciary exists because its proceedings are public records. But in this case, the government doesn't expect the public will inspect those records. The gamble is that the public won't be able to make sense of this Kafkaesque saga, so they won't even try. Meanwhile, state, local, and federal governments assist travelers in violating our civil rights, while travelers profits off of the back of the people of the state of California. After the denial of our petition en banc, we had to decide whether to petition to the U.S. Supreme Court or to address the big lie directly in state court. The fact that Moscow Mitch had assured the Senate's confirmation of beer-drinking Brett Kavanaugh to the U.S. Supreme Court weighed heavily into our decision. In state court, Ms. Bernier and I filed a motion under Code of Civil Procedure Section 391.8 and a complaint against travelers for the breach of our civil rights. Ms. Bernier's motion was file-stamped canceled and otherwise ignored. The state judge did address my motion, but just like the Ninth Circuit's response, that state court response was also false, arbitrary, and capricious. Our civil rights complaint was ignored and dismissed. Because it did not enjoin lawsuits over the payoff contract, the order prohibiting us from suing over the insurance policy in the Southern District was unclear. We filed a federal civil rights complaint in the Central District because that's where the insurance agent was located. Our complaint was assigned to Judge Percy Anderson, a black judge. Who better to understand a civil rights case than a black federal judge? After 12 years of oppression, Miss Bernier and I momentarily indulged in what we thought was a ray of hope. Miss Bernier told me, quote, "I hope he hasn't lost his blackness," unquote. But travelers promoted the big lie again with another specious, vexatious litigant motion. The same pattern of judicial abuse persisted. The magistrate said that we had filed a plethora of unsuccessful lawsuits on the same subject. He accused us of being delusional, having a vendetta against travelers and Jesse, and believing that our prior attorneys were easy prey. Even though Jesse had dragged us into his lawsuit, the magistrate behaved as if our civil rights lawsuit to challenge the illegal payoff contract was on the same subject as Miss Bernier's original lawsuit against Jesse over his destruction of her home back in 2007. All officers of all courts refer back to that first lawsuit without explaining how that first judge could have addressed the illegal payoff contract that wasn't negotiated until 2012. Travelers and Jesse have always acted this way because they knew the big lie would prevent us from retaining an attorney. Judge Anderson reviewed the magistrate's order, purportedly de novo, but did not respond to any of our objections. Judge Anderson was not the first judge to flaunt the law under our noses as if to taunt us to call him out on it. That would mean paying more in court fees, only to be ignored again in the same way and in perpetuum. He issued an order prohibiting us from suing travelers over the policy in the Central District, once again exactly the same way travelers had requested it. Our lawsuit asked for travelers to pay us an attorney in order to respond to Jesse's subpoena. The validity of the payoff contract was the subject matter. Our lawsuit wasn't about the policy. The judge's dismissal order was irrelevant. It's clear that he never read our complaint. Once again, that dismissal order did not address Jesse's pending harassing subpoenas, so there was nothing meaningful about it. By this time, Jesse's lawsuit against Attorney Rosen had been tried and was pending in the California 4th District Court of Appeal. Without an attorney, we still had no way of responding to Jesse's subpoenas. Our rights to access the state court had been repeatedly violated, and the big lie accusations, without facts, had always been the only justification. The dismissal orders in the Southern and Central districts were unclear. Each judge had granted whatever travelers wanted without addressing the merits of our civil rights claims. The CDI could no longer rely on pending litigation and Insurance Code Section 12921.3, Subdivision B sub 2, to decline to investigate Ms. Bernier's consumer complaints and take final action pursuant to Section 12921.4. We went back to the CDI and insisted on the investigation and to have it take its final action. The CDI relied on the big lie to deny an investigation. Just like the courts are doing, the CDI refused to take any further complaints from us. That left us with no choice but to sue Ricardo Lara and the California Department of Insurance. Because the big lie was preventing us from filing any type of litigation in state courts against anyone, we went back to the Southern District. We filed a civil rights lawsuit to obtain a writ of mandate in order to have the CDI take that final action. That lawsuit was assigned to Judge Curiel. We did not sue for money. We asked to stop the 4th District from deciding Rosen's appeal, to aid the jurisdiction of the Southern District, to require the CDI to investigate Ms. Bernier's consumer complaint, and to share those findings with the parties and with the court in that appeal. Judge Anello, the same judge who issued the order prohibiting us from suing over the insurance policy in the Southern District, jumped into our lawsuit, with Judge Curiel's consent, and dismissed it within 1 week, before Javier Becerra could make an appearance on behalf of Ricardo Lara and the CDI. The only justification that Judge Anello gave for dismissing our lawsuit was his order prohibiting us from suing travelers over the insurance policy, but this lawsuit was a writ of mandate to have the CDI take its final action in Ms. Bernier's consumer complaint. We appealed to the Ninth Circuit. Naturally, because Javier Becerra had not appeared for Ricardo Lara and the CDI, the Ninth Circuit issued a briefing schedule that only provided for one opening brief on appeal. The briefing schedule could not provide for an answer by a party that had not appeared. The issue on appeal is Judge Anello's dismissal order. That issue was between us and Judge Anello. There is nothing in the record from A.G. Becerra prior to that dismissal order, so we filed our opening brief, our excerpts of the record, and a motion to take judicial notice of the 3 years of judicial abuse in federal and state courts. A.G. Becerra then made a motion to intervene into our appeal. He's not a private attorney. He was elected by the people of the state of California as the Attorney General for its Department of Justice. The people did not elect Javier Becerra to aid and abet an ongoing elder abuse. If the DOJ seeks to intervene into your civil litigation, you should not have to fear that its objective is to do further injustice. He already had our opening brief in his possession before he made his motion to intervene. Why intervene in litigation that you don't intend to meaningfully address? After 13 years of oppression, Ms. Bernier and I thought that we would finally see a comprehensive investigation by the DOJ. Ms. Bernier and I momentarily indulged in that renewed ray of hope. That ray of hope quickly faded when A.G. Becerra refused to do anything prior to the oral hearing of Attorney Rosen's appeal, the last opportunity for the 4th District to consider our testimonies in response to Jesse's harassing subpoenas. That's when we predicted that the same pattern of judicial abuse would persist. Indeed, A.G. Becerra promoted the big lie. His answering brief has only one citation, Montesano v. Seafirst Commercial Corporation, a Fifth Circuit case that he relied on for its steris decisis principle. Steris decisis means to stand by things decided. He argued that principle in support of the Ninth Circuit's affirmation of Judge Anello's prior injunctive order against the policy, not the Judge Anello's subsequent dismissal of our civil rights case against Commissioner Lara and the CDI. He also relied on Judge Percy Anderson's order in the Central District, which had also been based on the Big Lie. A.G. Becerra is urging the Ninth Circuit to interpret Judge Anello's prior injunctive order, prohibiting us from suing over the policy, to apply to the CDI's lack of a final action on Travelers' illegal payoff contract. There is no court order, state or federal, prohibiting us from challenging its validity in any form. In fact, that illegal payoff contract explicitly requires us to be the ones to enforce it. The law is clear that nobody may be stopped from denying its validity. He argues that Judge Anello's injunctive order covers material pertaining to the policy. He argues that Travelers' illegal payoff contract pertains or relates to the policy. But he does not explain how challenging the illegal payoff contract in response to Jesse's subpoenas could be frivolous or harassing. He does not meaningfully address any of the issues explicitly raised by our opening brief on appeal. It's clear that he did not read or understand the 14 years of abuse. Our opening brief explained that almost 10 years had passed between the destruction of Miss Bernier's home in 2007 and the date that we were served with Jesse's subpoenas in 2017. He accused us of misreporting the dates of our own story, which he didn't read or understand. The same pattern of judicial abuse persisted. Like the DA had done, A.G. Becerra acted in concert with the crime that he had an obligation to investigate. On June 25, 2020, during the pandemic, we replied to his answer. We pointed out all of his factual and legal errors. Unlike the Ninth Circuit's denial of our prior appeal within 5 days, this appeal, which he argues is related to that appeal, has now been pending for over a year. We expect that the Ninth Circuit will answer sometime in 2023. Even then, we expect that the Big Lie will be its only justification for ignoring that appeal too. And ultimately, we predict that all government institutions will claim that it's too late to meaningfully address this ongoing abuse. That was the shortest way to tell our story without omitting any crucial detail. Since 2007, Miss Bernier and I have been dragged into court, sometimes as often as 4 times a week. The costs and fees I mentioned are just a small fraction of the total we've spent to try to defend ourselves and protect what's left of her home. We have numerous bankers' boxes of documents related to the entire saga. This is a Visio timeline of all the related litigation. This is an Excel spreadsheet of all the costs, damages, fees, and expenses. Despite all our efforts, we never had a meaningful day in court. If you're wondering if that day must be meaningful, the answer is yes, and that U.S. Supreme Court case is Minnesota Board Community for Colleges v. Knight at page 308. Several types of insurances are involved, from Travelers to UCIC to Jesse's Homeowners Insurance, Farmers, to Alicia Dern's Malpractice Insurance, Navigators, just to name a few. Yet none of them have ever paid Miss Bernier a dime, and the CDI will not investigate any of them if that complaint is from either of us. As a result, Miss Bernier's home remains hazardous to her health. In 2017, we had to apply thousands of dollars in stucco sealer to her exterior walls. They had been leaking since 2008. In 2020, I had to remove and replace all exterior doors. They too had been leaking since 2008. I still have to remove, re-engineer, and replace a leaky roof deck and at least 2 leaky windows. Jesse disconnected the pool from the house, so the city had to put fish in our pool. The city keeps checking in on us for potential mosquito vector problems. The city keeps asking us when the home will be finished according to the plans on file so it can adjust our property taxes. When the IRS audited Miss Bernier and discovered that all insurances have been paying Jesse but not Miss Bernier, the IRS, like the local police, are astonished. Despite all of this, A.G. Becerra has the audacity to suggest that if we refile our civil rights lawsuit, pay more in filing fees to the court, and this time we do whatever Judge Anello may have subjectively wanted, never mind what he actually and objectively said in his order, then we will finally have our meaningful day in court. Our civil rights lawsuit asked to stop the 4th District from deciding Attorney Rosen's appeal to aid the jurisdiction of the Southern District, to require the CDI to investigate Miss Bernier's consumer complaint, and to share those findings with the parties and with the court in that appeal. Attorney Rosen's appeal was decided on May 12, 2020, after A.G. Becerra got served with our opening brief on March 16, 2020, and after we prompted him again to act on April 14, 2020. He refused to take any position on Attorney Rosen's appeal. Now he suggests that we should challenge the payoff contract again in order to get an attorney to respond to Jesse's deposition, and the fact that Attorney Rosen's appeal has already been decided won't be relied on to perpetuate the big lie, call us vexatious, have us post an unaffordable bond, and dismiss that lawsuit too, but keep our filing fees. Justice delayed is justice denied. But here, justice is being denied under the appearance of delay until my mother dies of old age, so that the matter is never meaningfully resolved. In jurisprudence, there are two considerations: actual justice and the appearance of justice. We allege that we have been denied the appearance of justice. In fact, in our opening brief on appeal, we claim unusual circumstances pursuant to 28 U.S.C. Section 2106. Some of you may be old enough to remember the closing statement of the People's Court. Quote, "Don't take the law into your own hands, you take them to court." Unquote. Our story demonstrates what happens when you peacefully follow orders in protest. They say that doing the same thing over and over again, but expecting a different result each time, is the definition of insanity. Each time we're subpoenaed, we comply. Each time we expect a different result: justice. The purpose of the court is to give the people a place to go instead of resolving their disputes on the streets or by rioting the U.S. Capitol. In reference to the murder of George Floyd, if anybody had a right to put their white knees on a black man's neck, it would be the victims of a big lie whose proverbial knees belong on the judge's neck, who refuses to read and meaningfully respond to any civil rights complaint. Any such judge would still have the right to judge against those victims. That's what judges are for. But if the judgment is a dismissal based on vexatiousness, then that judge would first have to make a specific substantive finding explaining what's frivolous or harassing about that civil rights claim. Being black does not excuse a federal judge from enforcing civil rights. What this story demonstrates is that America is not the land of opportunity. It's the land of opportunists. A nation of laws would deliver actual justice, but this nation is so blind out of spite that it can't even deliver an appearance of justice. A nation of tribes would only deliver the appearance of justice, at best, because it's not about the right to live in dignity, a guarantee made to each individual under the 14th Amendment. It's about the appearance of justice that shakes out from the two biggest tribes, the Democrats and the Republicans. This country was always about getting the Democrats and the Republicans to agree amongst themselves, to settle their own differences before independent law intervenes. In actual reality, the latter was never a feasible option. The independent judicial option was always just a last resort illusion or appearance of justice. But now we live in an age where it's more profitable for the Republicans and the Democrats to always disagree, and that profit is made off the backs of their constituents, like Facebook makes its profit off the backs of its newsfeed subscribers. Democrats and Republicans are each connected to tribal business and to Hollywood's bully pulpit. America claims that there are three co-equal branches of government: the executive, the legislative, and the judicial. But if each is co-equal, then why would the judicial branch decide a dispute over the results of the election? The judiciary stayed out of this election dispute. But what if minority voters had all been blacklisted so that the judiciary would have messed up Trump's election lawsuits as bad as it messed up our civil rights lawsuits? Wait, come to think of it, isn't that what the Republicans are trying to do now? Despite A.G. Becerra's inhumane behavior towards Miss Bernier, an elder immigrant health care worker retired from the San Diego County Sheriff's Department of all honorable institutions, and when the whole world owes health care workers a higher standard of respect if they're expected to get us out of this pandemic, President Biden thought that it would be appropriate to promote A.G. Becerra to the one federal agency responsible for handling the pandemic and the immigration crisis. And now, inhumane mistreatment of migrants by U.S. Border Patrol on horses has surfaced. That inhumane mistreatment caused the dispersal of a crowd of 15,000 migrants potentially infected with COVID-19. So under the Biden administration, the mishandled pandemic is compounded by the mishandled immigration crisis. Nevertheless, Ms. Bernier and I have different beliefs. I believe that the administration of the most powerful nation on earth makes Joe Biden responsible for scrutinizing the background of anyone he appoints to any federal position. Ms. Bernier, who must conceal her identity as a result of this ongoing abuse, believes that the Kafkaesque nature of this 14-year-long ordeal makes holding Joe Biden responsible for promoting Becerra and Harris to federal positions an unreasonably onerous burden. I now address the Biden administration. Hello, President Biden. Thanks for watching my show. At your inauguration, singer Katy Perry performed her song Fireworks in front of the Pool of Reflection, commemorating the loss of what were then 400,000 lives lost to the pandemic. Did you know that in her video, Miss Perry points to the moon as she exposes her Sanskrit tattoo on her right arm, matching the tattoo of her then ex-fiancé Russell Brand, who's now a political activist? I have a true story about my own graphite tattoo on my left arm involving singer Jonathan Davis, whom Obama mentioned during a Medal of Honor ceremony, Katy Perry, and Ellen Kay, the Queen of Hollywood. That story is now the About Me page of the new AeroFusion.com, the official home of the Build Back Better show. I first told my story to Ellen Kay by personally delivering it to her Burbank studios on July 29, 2021. At that time, AeroFusion.com was offline. My story was in the form of a top-secret comic. It was top secret because I could not be on social media due to the unjustified judicial target on my back. The state and federal governments made me a black sheep of the nation by calling me a vexatious Canuck 12 years ago. That violated more than just my First Amendment right to redress my grievances in civil court or to complain to criminal law enforcement. That blacklisting also violated my right to peacefully assemble and to protest on Twitter, Instagram, Facebook, and social media in general. If my mother and I had exposed our daily lives on social media, then Jesse, all insurance companies, and all attorneys would have abused that information to shake us down and to harass us again with the big lie. What America is doing to us with its judicial big lie is similar to how China blacklists its people with its social credit system. Because my First Amendment right to redress the awful truth continues to be suppressed, I explained my enduring personal struggles against discrimination, hatred, and bias as a feel-good story in response to Hollywood's solicitation. Ellen has been known to do podcasts and radio shows involving people in her own life and her past. It doesn't look like she personally knew George Floyd, but when 26 million protesters took to the streets, she voiced her influence to stop the hate. On the other hand, Ellen did personally know me 34 years ago. When I personally delivered my feel-good story, along with a letter, a USB flash drive of my rough scripts of this first Build Back Better show, and a $200 bottle of Dom Perignon, Ellen Kay, Ryan Mano, and social queen Darlene looked me up on social media. I know this because LinkedIn notified me. When they noticed that I was a nobody, they stayed quiet. Not even a private email to acknowledge me and to say thanks, but no thanks. I clarify that Ellen wasn't being mean. She was being cautious. She wouldn't be the Queen of Hollywood if she had not been careful about whom she voices her influential opinion. In my letter, I told Ellen that I'd be hosting this show and that my comic would become the About Me page of the new AeroFusion.com. She knew that her private email to me wouldn't stay private for long. She understands that the words of influential people are weighty. She understands that her influence should be dispersed sparingly, much like this nation should speak softly but carry a big stick, not the other way around. Hollywood's influence, like that of the White House, is a bully pulpit, for good or for bad. What Ellen needed to know is who my tribe is today, not who I was 34 years ago. Yet my living like a fugitive prevented her from sensing the controversy surrounding me. Without knowing who the messenger is, not what the messenger's story is, even if she's a part of that story. She couldn't decide whether to voice her opinion and help expose this abuse, or to stay quiet because the tribe oppressing us is more powerful. It's not about the facts. It's about the power to suppress those facts. When judges accuse you of being delusional and having a vendetta against the criminal who's victimizing you, the color of law is involved. So how do you voice your opinion in support of that victim without joining that same echo chamber? It makes no sense to voice your opinion in support of 1 million potential future listeners if doing so costs you 2 million current listeners. Likewise, it makes no sense to gain 1 million potential future voters if doing so costs you 2 million current tax-paying voters. In my graphite tattoo story, I admit that 34 years ago I was jealous of Ellen. I believed that her aesthetic appearance would be the only reason for her success. But now I stand up for Ellen's right to stay quiet in response to my story that she solicited from me, as firm as I stand for all democratic values. Ellen has more than just a lovely voice. She's a classic Albert Einstein type of gal who wants to know more about astronomy from experts like Elon Musk. On the other hand, I'm a quantum Niels Bohr type of guy. I don't believe that the moon is really there when I'm not looking at it. Einstein and Bohr argued about this stuff all the time. But I digress. Had it not been for a teenager with a cell phone and social media, the news of the murder of George Floyd would not have been reported as a murder at all. Like a tree in the forest with nobody there to hear it fall, the news would have misreported the murder of that day. Mr. Floyd would have been blamed for his own death. There would not have been a trial of his murder. Without a trial, Derek Chauvin could never have been convicted. Without the true facts being reported, the law would not have been changed within a year of his murder. Ellen would not have had an opportunity to voice her influence to stop the hate and to stand with the Black Lives Matter movement in protest. For all that Ellen would have known based on the misreported news that day, causes other than Officer Chauvin's knee on Mr. Floyd's neck would have been the substantial cause of his death. Officer Chauvin would have argued that he had done what he was trained to do over the course of his honorable 19 years of law enforcement. Without the pressures of a publicly well-funded criminal trial, Officer Chauvin would have been at least successfully heard to argue that the hostile crowd filming the murder had distracted him from properly administering his law enforcement duties. It was never about the facts of Mr. Floyd's murder. It was always about the appearance of 26 million protesters who took to the streets because they witnessed the murder for themselves on social media. When enough people stand up and fight, the courts finally get bullied into doing what's right. Even Britney Spears has noticed that social media can bully the courts into doing what's right. But in a true nation of laws, the courts should not have to be bullied into doing what's right. Even worse, Jesse proved that, like Trump, he too can incite powerful tribes like insurances, officers of the court, and the machinery of government itself into doing what's wrong. My mother's life, mental, and emotional well-being have been slowly drained from her over the past 14 years. At the cost of being smeared all of my life and the loss of a family of my own, I remain dedicated to defending my mother against this ongoing harassment. Since 2007, neither of us has lived in dignity as guaranteed by the 14th Amendment. My mother and I have been knocking on the door of every government institution since 2007, including the Inter-American Commission on Human Rights. When no one else would listen, I responded to Hollywood's solicitation. Hollywood is private, government is public. Conspiracy theories suggest a connection between powerful business tribes such as insurance companies, Hollywood, Silicon Valley, and the government. As explained in my trailer, debunking conspiracy theories is a main focus of this show. Should anything I say be false, I expect Google, YouTube, and Facebook's Supreme Court to call me out on it. In theory, the U.S. Constitution protects the right of each individual, In reality, powerful tribes can motivate the government to secretly violate human rights for 14 years. Powerful tribe leaders enjoy an honor system that's unavailable to the rest of us. In a democratic republic, Hollywood's reaction to my feel-good story is perfectly fine, but the government's reaction to our 14 years of pleas for its own abuse against us to stop is not fine. My mother and I have written you a letter and a criminal complaint against Javier Becerra, which is also addressed to the U.S. Department of Justice. When federal judicial corruption violated our federal rights, we complained to the FBI twice. We were ignored twice. Now AG Becerra has acted in concert with criminals to continue to oppress our civil rights. We now bypass the FBI and complain directly to the U.S. Department of Justice and to the White House. We make it public on this show so that all nations may witness for themselves the nature of our criminal charges and America's response thereto. We respectfully demand meaningful justification for the way that we've been mistreated over the past 14 years. We respectfully demand proof that Travelers' $325,000 payoff contract with Jesse is legal. We also warn America that if the federal government refuses to investigate or explain this ongoing crime, then it'll be violating our human rights in lockstep with the California DOJ. The magistrate in the Central District said that the court would not parse through all the prior court orders and judgments. But that wasn't the pertinent question raised by Travelers' motion. The pertinent question is which prior order or judgment prevents us from challenging Travelers' illegal payoff contract with Jesse. We had already told Judge Anello about Civil Code of Procedure Section 391.2. Judge Anello had no choice but to agree that there's no res judicata effect to the state court's order that we post a $100,000 bond and from our failure to afford that bond. Without res judicata, the court had to give us notice of the specific vice of harassment or frivolousness. Instead, the federal court joined the state court by ordering us to post a $100,000 bond. Judge Anello then dismissed our civil rights case without prejudice when we failed to afford that bond. He never gave us any substantive notice explaining why or how it could be frivolous or harassing to challenge the illegal nature of Travelers' settlement in response to Jesse's harassing subpoenas. Then, mysteriously, the sealed evidence that Sheriff Hale had confiscated turned up missing from Judge Anello's chambers. Even though insurance matters are the responsibility of the states, you stood up against the insurances and on behalf of homeowners affected by Hurricane Ida. You did more than just throw rolls of paper towels into a crowd desperate for relief. Hurricanes, an illness like glioblastoma, and the pandemic are unavoidable natural tragedies. But instead of glioblastoma, I respectfully ask you to imagine that your son Beau had been struck by a drunk driver. The drunk driver walks away without a scratch. There's still hope for your son, who's fighting for his life in a coma. But the drunk driver convinces his own insurance and your son's insurance to pay him and to pull the plug on your son's life support equipment. For 14 years, Beau has to fight the drunk driver, public and private officers of the court, the insurances, the district attorney, the Department of Insurance, the Department of Justice, the state and federal government, and even the Inter-American Commission on Human Rights. But since the drunk driver is repeatedly rewarded, he harasses your son for profit until Beau ultimately dies from the abuse, but not from the accident. No country that engages in this type of abuse would seriously call itself a nation of laws. My mother and I now file criminal charges against Javier Becerra and his Deputy Attorney General, Laura Robbins, for having violated our civil rights under the color of law. AGs Becerra and Robbins acted in concert with all prior officers of the court by intentionally ignoring the illegal nature of the payoff contract in order to keep this elder abuse quiet. The same spiteful attitude is apparent from their specious Ninth Circuit answering brief. In addition, in the comments below, We've lodged the entire $5,000 trial transcript of the first lawsuit so that the US DOJ can specify exactly what it is that Ms. Bernier is being accused of having lied about. Whatever the DOJ's response is, those actions, or its failures to act, will be openly discussed on this show because free nations have nothing to hide. Finally, it's shameful that a Canadian is reminding America that democracy is not a spectator sport. If there's anything that this nation should have learned from President Trump, it's that America must immediately stand united if democracy has any chance to survive oligarchs, despots, and strongmen. Democracy must fight 4 wars at the same time. There's climate breakdown, environmental and industrial pollution. There's been a politicized pandemic for 2 years now. Pandemic variants are already here. It's not unreasonable to expect more variants in the near future. Nuclear, international wars always loom over the horizon. Meanwhile, and perhaps most shameful, domestic terror and violence, discrimination, hatred, bias, and inequality based on economic status, age, color, race, sex, sexual orientation, or a lack thereof, nation of origin, and political affiliation is rampant. I welcome you to my YouTube channel, inspired by your own political slogan and agenda. The Queen of Hollywood helped me to prove that depressing stories, true as they may be, about Mr. Hans Croteau with no social media followers or social life at all, just won't do. If we are to be subjected to political controversy all year long, the new American sport that seems to have replaced baseball, apple pie, football, hamburgers, and beer, then someone will have to educate in the sciences and humanities, all while being entertaining and imaginative in a Hollywood feel-good way. At his inauguration, unlike President Trump's American carnage speech, John F. Kennedy inspired this nation by asking not what your country can do for you, but what you can do for your country. But in the modern age, that suggestion would get laughed at, booed, and heckled. On the other hand, I bet that if Stan Lee was alive today, he'd inspire millennials with the power of his imagination. He'd educate them in a painless and entertaining way. Instead of a nobody like Mr. Hans Croteau, and since this show is Canadian, he'd have Captain Canuck as its host to help your administration build back better.